Hello,
Good
Mr.
morning, Your Honor. I
Axelman.
apologize for the delay.
Okay, no problem. Is there going to be anyone else appearing on behalf of the appellees?
I'm sorry, I couldn't hear you.
Will there be anyone else appearing on behalf of the appellees?
No, Your Honor.
Okay. All right, then we'll go ahead and get started. This is the case of the Orlando Bar Group. Okay, there's an echo from someone. Let's try this. Mr. Axelman, if you'll mute your
Yes,
screen
I
there.
apologize.
I don't know what we're going to do when you're arguing, though, because I think we're getting an echo from your computer. So
probably when Mr. Axelman's arguing, Mr. Simmons mutes his. Hopefully that's may solve the problem. We'll find out, I guess.
okay. All right. Well, this is the case of Orlando Bar Group versus Governor DeSantis et al. Case 21-1248. These arguments are being live streamed so that the public does have an opportunity to view them. They're also being recorded. Each side will have 20 minutes. Mr. Simmons, how much time do you wish to reserve for rebuttal?
5 minutes, Your Honor.
Okay, there is a clock on the screen, but I'll try to help you as well. And Mr. Simmons, you may proceed with your argument.
May it please the court. Also, Deborah Mitchell, one of my partners, is here with me as well. And Spencer Munns of the Bogut Munns and Munns firm and Joe Shoemaker of that firm also are watching on the live stream. The issue in this case arises out of executive orders that were issued by the state of Florida and in Orange County arising out of the COVID-19 pandemic. And we do agree with the governor that it was an error to go ahead and do these closure orders, and that there is no reason to have shut down any business during this time period. And of course, that the constitutional standard that exists here in the state of Florida is exactly opposite to the position that the appellees, the defendants, have taken, as shown in their oral argument, as shown in their briefs, and as shown as to the order that was entered by the judge dismissing this case with prejudice.
Mr. Simmons,
yes, Your Honor.
how many days were your clients totally shut down?
Approximately 6 months, Your Honor.
Completely shut down, not allowed to sell package or seated service or anything. I want to know totally shut down.
The orders that were entered in accordance with the plan stated that the businesses were closed. There are also, and there is the argument that the appellees make that it is only the suspension of the sale of alcohol beverages under the March 17th order, which ultimately morphed into one that permitted package sales that Your Honor is referring to. But the effect of these was to remove any kind of substantial ability to operate these businesses. And as the Keshbro case, which is the Florida Supreme Court case, which is the controlling case here in the state of Florida, and it's adopting using, we believe, the Florida Constitution, as well as the Abu Qadir case by the Second District Court of Appeals that was decided in 2020. Those two cases make it very clear that the temporary takings, which deny a landowner all of the use of his property, and they define that ultimately to be the substantial ability to operate his property, is the kind of permanent taking for which the Constitution clearly requires compensation. The whole premise of the defendant appellee's argument is that the case of what is called Tahoe Sierra versus the Tahoe Planning Council Agency. And they even argue, as they argued to the judge, that that the cases of Keshbro, which specifically provide for the compensation that should be paid in the event that there is a shutdown of a business, even for a short period of time. And it's true that the trespass analysis would apply for just a very short term, as if if that were to be the case. But the point of it is that Keshbro makes it absolutely unequivocally clear that the analysis must be one in which if there is a shutdown of a business, even for a short period of time, that constitutes a per se categorical taking. And the argument that the defendants appellees take is that the Tahoe Sierra case somehow vitiates that. As a matter of fact, that's the word they use. They say, and here's in their oral argument that they made before the trial judge, and it seemed to interpret the U.S. Supreme Court's Lucas decision as allowing for categorical taking treatment of a temporary taking. That's talking about the Keshbro case. And they go ahead and they say that the decision by the U.S. Supreme Court basically vitiates is the word they use, the Florida Supreme Court's decision in Keshbro. Well, the fact of it is that it did not. As a matter of fact, is a very well-written, erudite opinion by the Florida Supreme Court that specifically says that it does analyze the Tahoe Sierra Preservation Council case, because at that time it had been decided by the Ninth Circuit Court of Appeals and had not been ultimately ruled upon by the U.S. Supreme Court. But they go ahead and they reject that analysis. The Florida Supreme Court, giving a thorough analysis of the Tahoe Sierra case on page number 6 of its opinion, says that in sum, we are unable to discern any meaningful distinction justifying the preclusion of prospectively temporary regulations from categorical treatment under Lucas. Then they go ahead because what had happened is the cities in that case had argued that the Tahoe Sierra case would be controlling, and the Florida Supreme Court specifically rejects it because the Ninth Circuit had already ruled that it was reversing the trial court and saying that in a moratorium type of case that there should be an ability to have no temporary taking, must use an approach that is the Penn Central approach. And the Florida Supreme Court says, moreover, the courts refusing to extend First English beyond the remedial genesis to prospectively temporary regulations have done so in the land use and planning arena, where an entirely different set of considerations are implicated from those in the context of nuisance abatement, where a landowner is being deprived of a property's dedicated use. The concerns specific to the regulation of land use and planning were noted by the Ninth Circuit in declining to apply Lucas's categorical taking analysis to the temporary taking claims of landowners in the Lake Tahoe region. The simple fact of it is, Your Honors, this case is controlled, by the way, the Abu Qadir case specifically. It appears that the only thing that was alleged in that case was a constitutional taking under Florida's constitution. And so,
Mr. Simmons, let me ask you, has the Florida Supreme Court directly addressed the question of whether Florida's taking laws is coextensive with the U.S. Supreme Court, or whether it differs in any way?
There have been cases, Your Honor, that have talked about the coextensive analysis, but the fact of it is that the Supreme Court of the United States has already said that the analysis, and this is by virtue of Cedar Point Nurseries, that what's happened is that this analysis that deals with the Lake Tahoe.
Excuse me, Mr. Simmons, was your answer to the question yes, they are considered coextensive, or no?
They have been considered, but they are not the same. They are coextensive, but they're not the same. The Florida Supreme Court is interpreted, as well as the Second District Court of Appeal in Abu Qadir has construed and interpreted the way I believe that when you're talking about the Keshbro analysis, that is exactly like the Cedar Point Nursery by the United States Supreme Court, which does permit under the federal constitution, a partial regulatory taking is a categorical per se taking, even though it's a part of it. So the
But
point
in the
of,
Cedar Point, Mr. Simmons, Cedar Point was a physical taking where they allowed people, I think the word they used was to invade the property. There was no such invasion of your client's property. Rather, it was sort of the inverse under your argument that people were not allowed to enter your property, correct?
that is correct, Your Honor, and that is
And so the
also-
difference is, the difference is if a regulation ordered your clients to let people park trucks on their property, that would be a physical invasion. If they ordered your clients not to permit trucks to be parked, that would be a regulatory matter and not a physical invasion. Would you agree with that?
No, Your Honor, I would not, because these, the analysis in the Cedar Point Nursery case is that there are a bundle of sticks, and these rights have to do with what you can do with your own property. And you can exclude people, you can permit people. So what has happened is they have refused the opportunity and the ability to let customers into these businesses. That is the same as a physical invasion. It is the same concept. It is a critically important right.
I'm
that
sorry,
we cannot-
which case draws that as a complete 100% analogy? Or is that just something that you're doing?
Your Honor, that is something that I believe is that is part and parcel of the Cedar Point Nursery case. And I also believe that the Florida Supreme Court has not been overruled, cannot be overruled, and specifically rejected the entire analysis that the defendant appellees have placed in this case, and that is that the Tahoe Sierra case permitted the kind of conduct that they're engaged in right now, or that they did engage in, so as to cause this really shutdown of the business for a period of approximately 6 months.
Mr. Simmons, let me do a follow-up on my question. If we agree with you as far as that the U.S. Supreme Court law dictates that you win, then the case is over. I mean, if the U.S. Supreme Court law supports your argument that there's been a taking, the case is over and you win, correct?
Your Honor, that's not the entirety of it. There must be the proof that under the facts and circumstances of this case, that there would be damage to each one of these.
Well, assuming there's damage, and they don't really seem to contest that. And the reason for that initial question is, if we disagree with your argument and that the U.S. Supreme Court law supports your opposing counsel's argument that a taking did not occur, do we go to the second issue of whether Florida law allows it, or is there no second issue because Florida Supreme Court says takings law is coextensive with the U.S. Supreme Court law? You understand my question?
Yes, Your Honor, and you do go to the second analysis because the Florida Constitution has been interpreted by the Florida Supreme Court, as well as another DCA that specifically analyzes this, which is the Abu Qadir case. And both of those cases, certainly the Abu Qadir case, applying Florida's constitutional law, says that you cannot shut down a business until you have done the analysis that the conduct that is sought to be stopped. In this case, in those cases, a nuisance, a public nuisance. In this case, the fact also a public nuisance, and that is operating a business that is causing the spread, or at least the thought that it would contribute to the spread of the COVID virus, without even analyzing the necessity of wearing masks, the social distancing, additional cleansing, and all kind of protocols, including taking temperatures of people who are guests coming in to see if they have a temperature. All of those things are what the U.S. Supreme Court has made really clear, not only in the analysis of Cedar Point, but also it's exactly consistent with what the Florida Supreme Court has done. But yes, I do agree that if somehow or the other there is the view that the U.S. Supreme Court does not cause this to be a categorical per se taking even for a limited period of time. And by the way, in the Cedar Point, they go ahead and explain that says this is not going to create some kind of problem. If it's for a short period of time, it'll be treated as a typical trespass type situation. But if it gets to be long enough so that you have caused this damage, then the answer is that a temporary taking has occurred. And that is what I believe that that Cedar Point has said. I believe that's what has been made clear by the other opinions by the U.S. Supreme Court, and that is the Roman Catholic Diocese versus Cuomo in 2020, when the Supreme Court justices granted an injunction against the implementation and the enforcement of certain rules that were done. And it's always enlightening to read as to what the Supreme Court members are thinking when they say, such as Justice Gorsuch has said, even if the Constitution has taken a holiday during the pandemic, it cannot become a sabbatical. And then Justice Kavanaugh said, but judicial deference in an emergency or a crisis does not mean wholesale judicial abdication, especially when important questions of religious discrimination, racial discrimination, free speech, and the like are raised. Your Honor, they have made it real clear. You do not shut down businesses without doing an analysis that, in fact, the business itself is the cause of the problem. The only thing that has been said about the businesses being a problem here in this case was the Department of Business and Professional Regulation saying that they suspected that young people were attending bars and caused the spread of COVID. And while restaurants were able to operate, all manner of other businesses were able to be operated. The fact of it is yes, the answer is, if your honors determine that the U.S. Supreme Court doesn't agree with what the Florida Supreme Court states, then you do move to the Florida Supreme Court's analysis, because it is a direct statement that has not been overruled here in the state of Florida. It is the controlling law in the state of Florida.
All right, you're at 4 minutes and 12 seconds. Let's go ahead and hear from your opponent.
Your Honor, if I could use 1 minute of my time that before I get to rebuttal.
Sure,
I
I apologize. Go ahead.
Your Honor, I also state that we have the right to amend. We have the absolute unqualified right to amend, to go ahead and state the other things that we believe, or further and more completely state the positions we've had. The Fifth DCA has agreed with of course, the Boca Berger decision by the Florida Supreme Court.
Mr. Simmons, you didn't move for rehearing. You never moved to amend. Is that correct?
That is correct, Your Honor, because the
then
order itself,
excuse me.
I'm sorry.
How do you get around the Vorbeck versus Benton court case and all the cases that are cited therein that says the normal rules of preservation of error apply?
Your Honor, those are if something were put in that was never argued. They argued that this should be dismissed with prejudice. And what happened is we had evinced that we could go ahead and amend. And what happened is that once the order that was entered specifically said, do not file a motion to amend, because and there's like 3 places where it says it would be futile. And I'm not in the business of after a judge says that it will be futile to file a motion to amend, to going ahead and doing it anyway. And so the court lost jurisdiction once it entered the final judgment, and therefore there is no ability to file a motion to amend.
The court lost jurisdiction. You still had the ability to file a motion for rehearing, and you did not. Is that correct?
That is correct. And the reason why is because it's not necessary to preserve the right, because it was not something that was just showed up in the final judgment that had not been argued. They argued it. It was put in there, and it specifically told us, do not file a motion to amend. And so, Your Honor, we believe that we do have the right to amend. And additionally, I want to point out this parade of horribles that was stated that says, oh, this is going to bankrupt the state of Florida. Not only was it inappropriate, it's inaccurate. My estimation, there's probably 3,000 bars in the state of Florida. If every one of them got, $100,000, it would be $300 million, it wouldn't be something that bankrupts the state of Florida. If every one of them got $10,000, it'd be $30 million. And that's if every one of them sued. So this parade of horribles type of situation, there were only two, thank God for the governor, there were only two types of businesses that were shut down. And those were bars and those were fitness facilities. So there is no parade of horribles here, nor should it have ever been brought up to suggest that. Thank you, Your Honor.
Thank you. Okay. Mr. Simmons, let's try, see how it works with you muting your
Yes, Your Honor.
screen there, and we'll see if we get an echo when Mr. Axelman responds.
Thank you, Your Honor. Is there an echo? Because I was having some issues earlier with my computer, and I can participate telephonically if that would help.
I think as long as all the rest of us mute, there's no problem. But when we do question you, there is a problem. So why don't you go ahead and proceed? And if one of the judges has a question, I'd ask you to quickly mute yourself. We'll try it that way. Mr. Axelman, go ahead and unmute yourself, and we'll stay muted until we have a question.
May it please the court. My name is David Axelman, and I represent the state defendants. I think there's the elephant in the room here that the appellants are ignoring in their brief Senate oral argument is the statute that we have cited, which specifically authorizes the governor during a state of emergency to suspend the privilege of selling alcohol. And that's all that he did with these emergency orders. But before addressing that, I would just like to clear up a few things that the appellants have argued regarding Keshbro and the Abu Qadir decision. The Keshbro decision did not say that there is a per se taking, and the Keshbro decision does not govern here. It is a nuisance case. And if I might, I'd like to simply quote the Florida Supreme Court's own description of what the issue was in the Keshbro decision. The Florida Supreme Court said that the issue was, quote, whether temporary closures ordered by nuisance abatement boards to abate public nuisances as defined by section 893.138 Florida statutes and the corresponding city code provisions constitute compensable takings. That was the issue in Keshbro. And Keshbro was decided while the Tahoe Sierra case was pending before the Supreme Court of the United States. The Florida Supreme Court in Keshbro analyzed the Ninth Circuit's decision in Tahoe Sierra. And at the time, there was some open issue about just how far the Supreme Court's Lucas decision extended. And the Ninth Circuit understood it to mean that you could have a temporary total taking. That was the state of the law at the time that the Florida Supreme Court considered Keshbro. Subsequently, the Supreme Court issued its Tahoe Sierra decision and clarified that no, you cannot have a temporary total taking. And the court rejected exactly what the appellants want the court to say here. The appellants are trying to say, even though this was a temporary restriction, we were effectively, precluded from selling alcohol for on-premises consumption for about 6 months. And therefore, as to those 6 months, there's a total taking. That's exactly the arguments that the appellants made in Tahoe Sierra and the Supreme Court rejected. And the Supreme Court rejected it for a rather obvious logical reason. The logical endpoint of that argument is that you could sever even a single day during which your business operations are interrupted, and you could argue that for that one day, there was a total taking. And therefore, there should be categorical taking treatment as to what that one day. The Supreme Court explicitly rejected that argument and said you cannot disaggregate one time period and called that a total taking of that temporary time period. And therefore, it explicitly ruled that you cannot have a temporary total taking. Therefore, if there's a temporary restriction, it has to be analyzed under the Penn Central test. That is what the Supreme Court said in Tahoe Sierra about a year after the Florida Supreme Court's Keshbro decision. And since that time, the Florida Supreme Court and the DCAs have all confirmed repeatedly that the Florida Takings Clause is interpreted coextensively, which means the same way as the Takings Clause of the United States Constitution. So there's no question that Florida follows the Supreme Court's guidance on the Takings Clause, not just for purposes of federal takings claim, but for Florida takings claim. And the Supreme Court emphatically rejected the plaintiff's position in its Tahoe Sierra decision in 2002. The Tahoe Sierra decision.
Mr. Axelman, if you can mute yourself just for a second, I have a question. All right, my question is, as far as the Florida statute on alcohol sales being, the governor has the right to suspend them during an emergency. I understand the relevancy of that with regard to your argument that Penn Central should apply, and that goes directly to the expectation factor, discussed by the U.S. Supreme Court. But if we were to accept Mr. Simmons' argument on the physical appropriation, would the existence of that statute be relevant?
Your Honor, I apologize. I'm gonna have to just call in because I'm still having too much echo on the computer, which did not happen yesterday, and I apologize for that. But I couldn't understand the question. If I could just have a moment and call. Thank you.
Are you able to hear me?
Yes. Mr. Axelman, so my question was, I understand your argument as far as the Florida law authorizing the governor to suspend alcohol sales during an emergency, and how if you applied Penn Central, that would be relevant because it would go to the expectation factor of the property owner. My question is, if we were to accept Mr. Simmons' argument that this is a physical appropriation case, would the existence of that statute be relevant?
The existence of that statute would still, it's relevant because there are really only two categories of takings claim on the whole. There's the per se categorical taking, and then there's the as applied Penn Central taking. With regard to the former, the Supreme Court has only recognized a couple categories of takings that warrant per se treatment, and that is physical appropriation or physical invasion of property. So if to the extent that they're alleging a total taking, that statute is still relevant and dispositive because it is a background principle of state property law that authorizes the government action. And Lucas said, even if you have a complete, permanent, 100% destruction of the value of a protected property interest, there's still no taking if the regulation does no more than what the state could have done under the property law. Now, if there was a physical appropriation, would the statute still defeat the claim? I don't think so, but there was plainly no physical appropriation, and they didn't allege it, and they can't allege it because the emergency orders speak for themselves.
Thank you.
Thank you. And just briefly on Cedar Point, as we explained in the brief, the appellants are trying to conflate the concept of the right to exclude from the right to regulate access generally. Only the taking of a right to exclude has ever been recognized as a categorical taking. That's all Cedar Point was about, and I think the court picked up on that. But just to be clear, the right to regulate access is emphatically not the same thing as the right to exclude. And what they're really talking about is a use restriction. The Supreme Court in Cedar Point
Mr. Axelman?
specifically Yes.
I have a question for you now. If the governor ordered the businesses shut completely for 6 months, would that not be a physical taking in terms of denying everybody access to their own property?
It would not, if they ordered the business operations to completely stop for 6 months, no, it's still not a physical taking. And the cases, by the way, if we're talking about depriving the business owner of access to its own property, even then the categorical takings cases are limited to the physical destruction of the property. And they've cited cases such as the Florida Turnpike cases where there's an actual destruction of the way of ingress and egress from the property. That's different. But simply, suspending all use of a property even for 6 months still is not a physical taking of the property because it's not a physical destruction of access to the property. If there's any other questions on the takings issue, I'm happy to address those or on the amendment issue. But as the court pointed out, even after dismissal with prejudice is entered, you can still move for rehearing. They didn't do that. And I would also add that early in the proceedings, they sought judicial notice of various statements of the governor, and we opposed that. And among the various arguments we raised, the very first argument was if these comments were not pled, they're not part of the complaint, the court can't go outside the four corners on a motion to dismiss. So if you want the court to consider the governor's comments, you have to amend your complaint. We put that out there in March of last year and all but explicitly invited them to amend their complaint, and they still didn't. So I just wanted to bring that to the court's attention as well.
Mr. Axelman, let me follow up on that. If the trial court's order had said, I recognize it didn't, but if it had said no motions for rehearing will be entertained, then you would agree that issue could be appealed?
I would agree that issue, I'm sorry?
Could that issue be appealed, the failure to allow leave to amend, if the order had said no motion for rehearing will be entertained?
I think at least arguably you still have to try, although I understand that would put counsel in an uncomfortable position of, disobeying the court's order, which of course counsel wouldn't want to do. But I don't think the court has to decide that issue here because the court order said no such thing.
Right. So my next question though is, if the court order says any amendment would be futile, is that, it's not
No.
as strong as no motion for rehearing will be entertained, but does that change the analysis from the cases that do exist saying you got to ask for leave to amend or you have to file a motion for a hearing?
No, certainly not. I think counsel still has an obligation to explain to the court why it wouldn't be futile. I don't think that's distinguishable from any type of ruling, evidentiary or otherwise, where you can just then say, well, the court ruled against me and therefore, there's nothing left to do but go to the appellate court. The whole point of the rule of preservation is if you think that a trial judge is making an error or is about to make an error or has made an error that can still be corrected, you have to give the trial judge the first opportunity to avoid or correct the error. The Florida Supreme Court has recognized that that's the whole point of the rule of preservation. So just because the trial court says that an amendment would be futile, I certainly don't think that absolves the plaintiff of the responsibility to try to persuade the trial court otherwise.
Okay.
And by
thank
the
you.
way, there were,
Excuse me,
and I would just add,
Mr. Axelman, in terms of interference with property rights, isn't closing down a bar or these bars for a period of 6 months a much greater invasion than in Cedar Point, where they were allowed for whatever it was 120 days, several hours a day to be deprived of the total use of their property?
in one sense, in terms of, the amount of time at issue, Perhaps. However, respectfully, that's really not relevant to the analysis here because Cedar Point is confined to the categorical takings category. The Supreme Court has long recognized that actual physical invasions by the government are a special category of treatment. And whether it's a 1 week use restriction or a 6 month use restriction, even in Cedar Point, the court distinguished use restrictions and made clear that use restrictions are Penn Central claims. And this was on its face and in practice, this was a use restriction. It said you cannot use your property to sell alcohol for on-premises consumption. And by the way, there was only a period of 3 days where they couldn't sell alcohol. 3 days after that initial order, the order said you can sell for off-premises consumption, which is another reason why there's no total takings here, because there is no complete destruction of the value of property when you can still use it to sell alcohol to go, which they were able to do for all but 3 days of that period. And by the way, they actually alleged in their complaint that all you would have to do as a bar owner to escape these restrictions is to get a food service license from my agency and to make, in their words, nominal modifications to your business. And they said that some bar owners did so. And they also alleged, by the way, that 4 of the 6 of them have food service licenses. So the idea that there was some total taking, which requires a complete destruction of value, I mean, there's just no merit to that claim.
What's the relevancy, if any, of the argument you made in your answer brief that there's no allegations that these plaintiffs were the owners, or at least that all of them were the owners?
Of land, of the land.
Of the land as opposed to the alcohol license.
Sure. The relevance of that is that Lucas, which is, the seminal governing decision for what we call total takings, was a claim involving land use and only addressed land. And although there's still, some slight open question about it, the Supreme Court and really all the federal courts have cabined Lucas total taking claims to land. Therefore, it seems that the consensus is that if you're not arguing that the land was taken, you can't even argue that there's a total taking. And that's one of about 4 independent reasons why they have no total taking claim here. And any claim would have to be decided under Penn Central.
All right. Any other questions from the panel members? Do you have further argument, Mr. Axelrod?
No, thank you, Your Honor. We would just respectfully ask that the court affirm. Thank you.
Any other questions from the panel members? Okay, Mr. Simmons, rebuttal.
Yes, Your Honor, may it please the court. The statement about the use of the properties, the Keshbro case specifically says that the cities contend that the property owners were not deprived of all economically beneficial or productive uses of the property because they had other uses available to them under the terms of the closure orders. And the court says we disagree. It's dealing with the substantial denial of the use of the property. And that's what the Keshbro and the Abu Qadir case say. And so not only is Florida law clear that this analysis, that these properties had to be used as a nuisance in order to be shut down. This is unheard of, to be able to shut down businesses without being able to show that you're not in violation. The mischief that could occur and does occur as a result of that is pointed out in the Roman Catholic Diocese versus Cuomo case. And additionally, Your Honors, the Florida Supreme Court decision is in fact consistent with the Cedar Point Nurseries case. Cedar Point Nurseries, as well as the Cuomo case, make it clear that the U.S. Supreme Court agrees that the analysis must be that there can be a partial taking that constitutes a per se categorical right to compensation. And lastly, Your Honors, the idea that we be told as counsel, as officers of the court, do not file. It would be futile for you to file a motion for rehearing. And it says it like 3 times in the order. Then to go ahead and do as the appellees suggest is simply ignore that. That's one of their arguments, that we should have ignored it and simply filed a a motion to an amendment and ignore what the judge said. That's one of their arguments. The second point is, Your Honor, is you don't have to file a motion for rehearing when the judge has already told you that he's not going to listen to you. And in fact, and I don't mean that in an adverse way, I'm just saying that he's heard it, he's not going to consider it, and it would be futile for you to go ahead and ask to amend. And I don't believe that the Florida law says that. And so I would ask Your Honors to rule that the number one, the Keshpro and Abu Qadir control. They specifically rejected, and I disagree with Mr. Axelman's interpretation of what the Ninth Circuit did. The Ninth Circuit reversed the trial court in the Tahoe Sierra case. And so the Florida Supreme Court knew fully well about what was being said. And they specifically said, moratoria does not apply to the circumstances we're talking about. Specifically said, we're not going to rely upon that in this analysis. And then lastly, Your Honor, we would ask for the right to amend so that we may present all of the things that cannot be fully explicated in a hearing that's simply on a motion to dismiss that occurred in this case. And so we would ask for that. Thank you, Your Honor.
Time is up. Thank you both for your arguments, and we'll be in recess till 10 o'clock.